Hello, this is U.S. Immigration Attorney Sharifa Tharpe. As usual, I'm here live to take your U.S. immigration related questions. It can be anything that's immigration related, but I'm also here to talk to you about a great topic that I'm sure you will love. So that is, how long should you wait after marriage before applying for the green card? You will love the answer. And the simple answer is there's no wait time. There's no law that says, or no requirements that says that you have to wait before applying for permanent residence through marriage. If you get married today, you could file the paperwork tomorrow. Now, of course, that does not mean that there are not considerations that you have to review before submitting it. But if all is well with your petition, your application, and your relationship, it's time, once you get married, the day after, you could file it. But let me talk to you about those special considerations. While there's nothing that says you can't wait, and I have had clients that they've gotten married, so they've even gotten married internationally, and I have received their copy of the marriage certificate as soon as they got it. And while they were still honeymooning, we filed the petition. So there's nothing that says you can't do that. However, you want to make sure that to have a successful, smooth process without any unnecessary delays, you want to make sure that your petition, your application is the best that it can be at the time that you're submitting it. Because if not, then a lot of things can happen due to the haste in applying for it. And so that's where I would caution you to be careful as you're submitting this petition. And of course, this is what I help my clients with. Now, here are some things that you should be careful about when you're submitting the petition, right? The marriage certificate alone is not enough to prove that you qualify for permanent residence. This can be news to some people, and so I want to break it down. So there are two requirements. So, multiple requirements, but two very important requirements when you're applying for permanent residence through marriage. One is to show that you are legally married, but that's not the same as showing that you have a real bona fide marriage. So you do have to show that you're legally married. Because remember, in some cultures, some countries, you can do a religious ceremony, but it may not be recognized as a real marriage. It may be a symbolic marriage to you and your significant other and family members, but it may not be legally recognized in the country and therefore not legally recognized under immigration law. So you do have to prove that it's a legally recognized marriage. And then after you meet that requirement, you still have to go forward and show that you both intend to spend your lives together. This is going to be crucial when you are submitting this petition. And the evidence that it takes to to prove that is where a lot of time goes. You have to invest a lot of time into submitting that evidence. And it can be a number of different types of evidence. This is where I don't want you to have the expectation that this is a one size fits all situation, because every marriage is different. You have some traditional couples that as soon as they get married, you have you may have a gender role thing where maybe, the man is the breadwinner, the woman stays home, the man supports the household, that their property is jointly owned, like the car and the home or the lease. And then you may have some other marriages that's not the case. One of the spouses didn't adopt the name of the other one, usually the woman, which that's a personal decision and it doesn't affect the result of this type of petition. But that's one of the things. So maybe you haven't taken the name, maybe you don't the both of you haven't reached the point where you're going to go ahead and put your finances together. And so in a case like that, it really comes down to what are the both of you doing together to show that this is still genuine and that you are spending your lives together. It's just that you don't have that traditional type of, 1950s type of marriage going. For example, when it's time to divide the bills, if it's a 50-50 deal, you may Zell one spouse may Zell the other spouse. Hi there, Umesh. It's nice to see you on YouTube. Go ahead, put your question in. You can put your questions in, by the way, and then as soon as I'm finished talking about this topic, I will go ahead and jump to questions. So if, for example, you're Zelling, how you pay for your bills is you Zell each other. You may not have a joint bank account. And, remember that there are reasons that might be the case. These are marriages complex, relationships are complex. Maybe you haven't reached the point where you trust your spouse yet to commingle your funds. Maybe you both have a different idea of how you're going to manage your finances. And so if you agree to divide the bills and you sell each other, cash up each other, then it's going to show in your bank account. And I believe you can also pull your Zelle or your Cash App records to show who you are sending that money to. And so that could be one of those things that you're not going to see. They're not going to straight up request your Zelle records or your Cash App records. But this could be a good alternative to not having a joint bank account together. And let me raise this point too, that if don't try to be something that you're not, because this also raises a red flag to the officer. If you never had a joint bank account, I would say don't go. And I mean, if you truly intend to use that bank account, go, by all means, go ahead, put it together and use the bank account maybe for savings or for spending. But if that's not your true intention, it's going to come across to the officer as if it's a setup. That you are you just created a bank account to make it have the appearance that you are commingling your finances. So make it meaningful. The evidence should be meaningful. And the way that, I have had individuals come to me with either requests for evidence or notices to deny because the bank account was joint, but it was so skeletal. So red flag one is you just include the first page of your statement. You don't include the entire statement to paint that picture of what you're doing with the bank account. What's the purpose of the bank account? Are the both of you depositing money? Are you both of you spending money out of the account? Is that account used regularly? So if they just see the first page or just a verification letter from the bank, they can say, why did you choose to do that rather than to just give us the full statement? And that can raise questions about, they may discount this evidence as proof of bona fide marriage. And then the other red flag is if you are showing a joint bank account and you don't use it, and there's very little money in there, and it's like 3 months old. That can also be a red flag. So make sure that that's the bank account. If you're going to use a joint bank account, that it's meaningful, that there is some activity, that it does show that you both have some plans for that bank account. So that's just one example of how evidence, while you hear all the time joint bank account, joint bank account, joint bank account, but how evidence can turn on you and make you look bad if you don't present it in the right way. So keep that in mind, that you want to take the time. So after you get married, you want to take the time, or even before, by the way. So before you get married, But if you are choosing to prepare after you get married, take the time to make sure you understand what's required, that you customize your situation according to your facts and not necessarily what happened with another married couple, because every situation is different. Um, so, can you prepare to file beforehand? Absolutely. This is where I find couples do this, is where they have had solid history together. Maybe they've lived together before marriage and they have a history of joint leases. They have a history of commingling funds. They have shared in property together. Then yes, it would be great to show that history and then to show the marriage. And of course, even for example, the lease can go even be past the date of the marriage. Of course, you do want to show that the evidence is related to your marriage, but showing that you had a solid relationship beforehand can be strong evidence, and it can give your application some credibility in the eyes of the officer, to see that you've had relationship from maybe a year, 2 years ago. But that does not mean that you don't qualify if you don't have that kind of history. It just means that you have to now look to the future and pick out evidence that's going to show that you and your spouse are really working hard to build a life together. That's going to be key here. All right. So just to summarize, how long do you have to wait after marriage before applying for the green card? Don't have to wait. You don't have to wait. But I do want you to make sure that you take certain things into consideration. Even though you don't have to wait, don't just in haste submit a petition, an application with very little evidence attached, because oftentimes if you do that, you're setting the pace for unnecessary delays and a bad tense interview that can then lead to more delays. So prepare sufficiently to put your application together. But here's another thing to consider is in the case of adjustment of status. So you have been, say you came in on a B1, B2, and you would really like to move forward with submitting your petition after marriage. You have to keep in mind that there is what's called a 90-day rule. The 90-day rule, there is case law that states that the 90-day rule doesn't apply to spouses of U.S. citizens. However, when it comes on to the spouses of permanent residents, you should not be working. You should not be getting married in those 90 days. You should not be filing your papers in the 90 days, because that may create suspicion in the eyes of the officer that at the time that you were entering the country, you had with a B1, B2, because remember, when you're coming in with a visa, B1, B2, you're not supposed to have the intention to stay. And so if the officer sees these signs, then they could review to see if they have to apply that 90-day rule that says if you and this is based on policy here. So the policy manual, that if they see these kinds of actions, they can then attribute immigrant intent, and then that could lead to more problems like misrepresentation and fraud, because if you're presenting you're going to stay here temporarily but you really intended to stay here permanently, they could construe that as misrepresentation. So I would say that's something that a definite consideration for spouses of permanent residents. And then when it comes to working without a permit, spouses of permanent residents, until you get your work permit through adjustment of status, you should not be working without a permit, or you will be disqualified from filing for your permanent residence while staying in the United States. So you want to make sure that you sit tight while you're going through adjustment of status, you sit tight and you make sure you wait on that work permit. Also, spouses of permanent residents, while citizens of spouses of citizens can end up overstaying and still qualify for adjustment of status, that's not the same for spouses of permanent residents. So if you're the spouse of a green card holder, you should make sure that you file your papers before your time expires. So of course, there are the considerations, right? Say you have 3 months to stay in the U.S., but then after you arrive here, you say you really want to adjust status. You have to be mindful of those rules and whether you do have to. It's best for you to do it outside of the country versus doing it through adjustment of status, because you could run into these issues, like that 90-day rule. And then if you work without a permit, that's going to spell a lot of problems for you. All right, so thanks for your patience. I hope I gave you some really good information. Now I'm going to answer immigration questions. This can be anything that's immigration related. I gave you some general information. Always remember that this is not legal advice. And so if you're ready to file, you are getting married, you're doing anything, before you take action, get legal advice to make sure that you are on the right path, that you're not going to make any devastating mistakes that's going to disqualify you from qualifying for adjustment of status or permanent residence through your spouse or through any relative in the future. So let's go. Questions. Put those questions in. I'm going to go ahead and scroll through right now to see. So I do see one on YouTube. So I think this is how long does the I-130 take? So I would say the average time now is 12 months. That's the average time. It could be shorter, maybe even longer, but the average I'm seeing is about 12 months. All right. Thank you for joining. I'm scrolling through. Hang tight while I scroll through. If you typed your question in, I'm just scrolling through, waving and letting people know that I see you and thanks for joining. But I'm scrolling through for questions. So what comes after actively reviewing for spouse? So if they don't need anything else, the interview could come next, and you could also get the work permit if you haven't gotten it already. But then it usually means that an interview may be coming up, or if you played your card right and you submitted the right documentation, you will may get that green card in the mail. That is happening now. Hi there. I'm happy to see you too. Quick question. Will renewing my passport and changing my last name during the consular process cause a delay after the interview? So it should not. What you need to make sure that you do as soon as you update your passport, that you do provide that information to the NVC so they have it on record and that it's passed on to the embassy. Or if your interview comes very soon, just take your new passport as well as the old one you presented to the interview. Now, keep in mind, though, I'm not your attorney and I don't know your case, so you should not be depending on this information because it really sometimes it comes down to very specific information that we need. But renewing you are supposed to have a passport that has a validity of 6 months or more to be able to get that immigrant visa. If you don't, then that could delay your process. So make sure that you get on that right away. All right. So any idea about when, I guess, when you will get the decision after actively reviewing? Unfortunately not. With I-130s, I have been seeing an average of 12 months. Um, so my home country, wants my passport. Is it a bother? Um, is bother me to apply for citizenship? I am a green card holder. So I'm going to make some assumptions here because the sentence I'm not completely understanding. But if your home country wants your passport, just make sure you make copies of your passport, and then you can go ahead and apply for citizenship. But that's of course if you meet all the requirements for citizenship. All right, I'm seeing a bunch of questions, so keep those questions coming. How long will it take a green card holder to file for a spouse? So right now it's on the same timeline as a US citizen would file for their spouse. So it's a good time for permanent residents to apply as long as the spouse qualifies. Keep in mind, if you're a green card holder, your spouse is in the US and they're out of status, you have to be very cautious about that. Now, how long will it take? So if your spouse is outside of the US, 18 to 24 months. If they're in the US, then it could even be a few months up to a year. Um, do you have to be living with your spouse? That's a complex question, right? It raises a red flag for sure. But if you are outside of the US, if your immigrant spouse is outside of the US, then of course they're not going to expect you to be living together. If you're in the US, though, there is that expectation, and if you're not, you have to show really solid evidence as to why. What's the purpose of that? Is it that, I have had situations where the spouses are just doing this temporarily, but it happens to be at the same time that they're applying for permanent residence. But they have specific goals, and it is related to their life, spending their lives together. They may have different, they may be going to different schools. They may be on different career paths that they know in a short time one spouse can move to the other spouse, but right now they need to do that until they can make that transition. So, you're going to have to show a good, solid reason why you are living apart, the office that can raise a red flag. What if you're married and upon arrival to the States and receiving your green card, your spouse forces you to sign divorce papers, abuse you psychologically, and kicks you out? Now, if you have your 2-year permanent residence, you can apply for your own 10-year based on the abuse. This is what I help my clients with. So if you're going through this situation, you can get in touch with the office and we can help you with that. And you can file for that waiver right now to be able to apply on your own. You do have to submit special forms as well as specific evidence to make sure that you can get your tenure, but it is possible. And I'm so sorry that this happened to you or a friend or the person that you know. Hi, good day. My son became a citizen when his dad filed for him, but he has his 10th at Green Card and wants to get his certificate. His dad is not giving him a copy, so he can now file proper documents. So, in this case, it's complex just because now it involves the will of the dad. Like the dad is giving an issue, and so I'd have to understand what's going on. Maybe he can apply for proof of the proof of his dad's citizenship in other ways, but I need to understand what the situation is. So you can always schedule a consultation and we will talk. So he's now 21 but can't get to go to swear in because of his dad. Okay, so definitely I would need to evaluate your situation, because that's a situation that's very specific and not very not a common issue in regards to naturalization. Okay, so Madam, some people are saying no, they don't have to interview for the I-130. So it depends, right? Most people are still going to have an interview, especially if they're outside of the country. But keep in mind that that is for the immigrant visa, and it's going to depend on what kind of application you submitted and whether the embassy, maybe they feel like this is an easy case. If it's easy and you did everything, submitted everything, they don't have any questions, that could be possible. And that is happening in some cases. But the vast majority of individuals will probably have an interview, especially at the embassy. How frequently can you travel outside the USA on a conditional green card? So you can travel often, but you have to make sure that you don't stay outside of the country for more than 6 months, because that can really cause problems during citizenship, and it can raise um, some questions about whether you have abandoned your permanent residence. So my home country revoked my passport. It bothers me to apply for citizenship. I'm a green card holder. So, and I think this is Andu, you need a consultation, because I would want to understand why your home country revoked the passport. Because if they revoke the passport and it is related to your good moral character, then there could be a problem. Some things that could raise good moral character problems would be a failure to support your children. And I know in some countries, if there's failure to support children, like in the United States, they can deny you a passport. So I would want to understand, is it a criminal issue? If it's a criminal issue, that can definitely cause problems during citizenship. So you need a consultation for sure. Um, how long are current wait times for marriage green card with marriage to a US citizen? So I've seen as little as a couple of months, a few months, 5 months, and I've seen it go over a year. So 5 months, the average I'm seeing is 8 months, 8 to 12 months. Okay, so VAWA. So I am talking about a particular topic today, and that's a marriage permanent residence. But let me give you a little lowdown on the VAWA. So one, if you're being mistreated by a U.S. citizen or legal permanent resident spouse, a parent if you're under 21 and unmarried, and in some cases under 25, or by a U.S. citizen, son or daughter who is age 21 or over, you could qualify for your own relief. This kind of mistreatment does not have to be violent. It doesn't have to involve physical violence, but it could include extreme cruelty. If the person was intentionally cruel to you, toxic, they were controlling, they did things that affected you emotionally, then this could qualify you for VAWA. This is for men, this is for women, this is for transgender, it's for all genders. And it does not have to be a specific type of relationship to qualify, except, of course, you have to be married if this is a marital situation, and you do have to meet all the requirements for the parent-child relationship. I do help my clients. So one thing you should not be concerned about is I don't have the evidence. Any credible evidence is something that's permissible, but you should not be Xing yourself out because you have absolutely nothing. Your memory, your statement can be sufficient if presented properly. So if anybody is going through a situation like this, go ahead, call and schedule, and we will assist. Now, the way that you can schedule the consultation is by going to the link in the profile. When you click on the link, you're going to see everything that you need to book your own consultation. And if you need help to do it, you can go ahead and go to the website. You'll see the phone number. You'll see the contact form. You'll even see online chat, which is available up to 6:30 p.m. And all of those will lead to the scheduling coordinator who will be able to help you to schedule your appointment. I applied for a U visa October 2021 and got biometrics on December 1st. How long should it take? So they are transitioning to make sure that people can get work permits while they wait for the U visa to be processed, but you have to have a bona fide filing determination letter. And so that means that your background check came through, that you properly filed, and that you have a U certification. U visa, by the way, for those of you who are listening, the U visa that we're talking about is for victims of crime. And if you're a victim of certain crimes that resulted in your physical or mental abuse, so if it impacted you, even in an emotional way, the crime, and it was reported to the police, there does not have to be an arrest, there does not have to be a conviction. If this was reported to the police, so for example, stalking, domestic violence. So if, for example, speaking of VAWA, right, where I said you have to have the marital relationship. Well, if you didn't have the marital, maybe you were just living with your significant other, but not legally married, but you experienced domestic violence and it was reported to the police, then the U visa may be possible here. Now, when all of those requirements are met, they are issuing work permits. However, they are 10 years backed up. And so for them, they're trying to catch up because they just implemented the policy to say that while you're waiting for those 10 years to pass, you will get your work permit. But now they have thousands of people to backtrack to issue those work permits. So it is taking a while. It still can take over a year to get that work permit. Can I travel outside the US with an extension notice and an I-551 stamp if I lost my 2-year green card? So it's possible, yes. So if you have lost your permanent residence, but you have the I-551 stamp and it's valid, as well as the extension notice, you should be able to travel. Now, whether I recommend it is a whole other matter. You'd have to schedule a consultation. And it really I have to know a lot of details about your matter because if you are waiting to go to the 10-year, but maybe your case is iffy, or maybe there are a lot of problems in your matter, I would be a lot more cautious about traveling. But it's absolutely possible to travel with an extension letter and an I-551 stamp. Those are the same. Those are like temporary evidence. So usually they last about the I-551 stamp lasts about a year, and it is the same as showing a green card. So it is the same as a green card, except it just has a shorter validity date. All right, so that's gonna be it for me. Thanks so much for joining. I appreciate it. I enjoy talking to you about this topic. I will be back tomorrow at around 12 noon. So look out for me. And as soon as I come on, you can come on, type your questions. I will come with a topic and then we can take it from there. I see one more question. What's the waiting time after the U.S. spouse files an I-130? So it's approximately a year right now if you just filed an I-130. All right, Miss Pretty, it's nice to see you. If you are just joining and you missed the topic, I'm going to go ahead and post this as a replay. So just go ahead and look out for the replay and you can catch up. And it's a really good topic too. All right, have a good evening. Thanks so much for the love. I appreciate it. I will see you tomorrow. Bye-bye. Bye-bye.